building opens at 8:30.
Judge Constance Morrow, 8th Circuit. These are my credentials.
I need supervisor verification for badges like that.
My supervisor's the chief judge. Yours gets in at 8:15. I have a filing deadline at 8:24.
Everyone thinks their situation's urgent, ma'am.
How long have you been at this post?
6 days.
Rookie cop blocks black federal judge from entering building. Entry cameras cost him his badge. Officer Travis Webb, badge number 8847 of the Meridian City Police Department, had been on the force for 4 months when he was assigned to the security post at the entrance of the Meridian Federal Courthouse on a Monday morning in October. He had received his assignment briefing, his post instructions, and a laminated sheet showing the building's access protocols. The laminated sheet specified that individuals displaying valid federal judicial credentials were to be granted immediate access to the building without delay, that federal judges held the highest civilian priority in the building's access hierarchy, and that the credential verification process for judicial officers consisted of visual confirmation of the official federal judiciary identification card, followed by a log entry. At 7:58 in the morning, 12 minutes before the building's formal opening time and 42 minutes before the first scheduled proceeding in any courtroom, the Honorable Constance Morrow, appointed federal judge of the 8th Circuit, 23 years on the federal bench, former United States Attorney, the first black woman appointed to her circuit and the third black woman appointed to a federal appellate position in this district's history, approached the courthouse entrance in her work clothes, carrying a leather portfolio and a travel coffee mug, displayed her federal judicial credentials to Officer Webb, and was told that the building did not open until 8:30 and that she would need to wait outside. When Judge Morrow informed Webb that federal judicial officers were explicitly exempted from the general public access schedule and could enter the building at any time, Webb told her that he had not been informed of any such exemption and that his instructions said 8:30 for everyone. When she asked him to call his supervisor to verify, Webb told her his supervisor was not available until 8:15 and that he could not leave his post to find another officer. When she told him she had a sealed motion requiring her physical presence in her chambers before 8:30 to meet a filing deadline that could not be extended, Webb told her that he could not make exceptions based on claimed emergencies and that everyone felt their situation was urgent. When she told him she was a federal judge and produced her official credentials for the third time, Webb looked at the credentials, looked at her travel coffee mug, looked at her leather portfolio, looked at her, and told her that he needed to verify the credentials with a supervisor before he could allow access and that verification would have to wait until 8:15. He then stepped back to his post position, which placed his body between Judge Morrow and the entrance door, and told her that she was welcome to wait in the designated public waiting area to the left of the entrance. Judge Morrow looked at the public waiting area. She looked at Officer Webb. She looked at the 2 entry cameras mounted above the courthouse door, one pointed at the entrance approach and one pointed at the post position, both of which had been recording since 6 o'clock in the morning when the building's security system activated for the day. She set her travel coffee mug on the ledge beside the entrance. She took out her phone, and she made 3 calls in the next 4 minutes that would end Officer Travis Webb's 4-month law enforcement career before he reached the 6-month mark. Before we go further, what city or country are you watching from? Drop it in the comments right now. We love seeing where our community is watching from. If you believe a federal judge displaying her credentials at the entrance of the federal courthouse where she has worked for 23 years should never be told to wait in the public waiting area, because a 4-month officer needs supervisor verification until 8:15, then like this video and subscribe, because the 2 entry cameras above that courthouse door recorded everything, and what they recorded made Officer Webb's 4-month career its own case study in what happens when assumptions override a laminated instruction sheet. Constance Morrow had been appointed to the federal bench 23 years ago, after a career that had included 7 years as an assistant United States attorney, 4 years as a United States attorney, and 2 years at a federal appeals court clerkship that had produced, in the estimation of the judge she clerked for, the most thorough bench memoranda he had received in 11 years of accepting clerks. She had been confirmed by the Senate with bipartisan support. She had been the first black woman appointed to her circuit. She had written opinions that were cited in 41 subsequent federal decisions. She had been teaching a constitutional law seminar at the State University's law school every spring for 16 years, always on Monday mornings, which was why she arrived at the courthouse early on Mondays. Seminar at 9, pre-seminar chambers work at 8. The reliable rhythm of a schedule she had maintained for 16 consecutive years without significant variation. She knew the courthouse entrance protocols because she had been entering this building for 23 years. She knew the entry cameras because she had requested their installation 7 years earlier after an incident involving a witness intimidation attempt in the building's public corridor that the existing security footage had not covered adequately. She knew the laminated access protocol sheet because a version of it had been drafted by her chambers and distributed to courthouse security as part of the revised access policy she had championed. After a different incident 4 years earlier, she had not anticipated that the sheet would one day be cited as the reason a 4-month officer felt entitled to override her credentials, but 23 years of federal judicial experience had taught her to appreciate the irony that institutional documents produced to protect people occasionally required those same people to invoke them on their own behalf. She arrived at the courthouse at 7:58 every Monday. She had arrived at 7:58 every Monday for 16 years. The security officers who worked the Morning Post knew her. Not because she had introduced herself with her title, but because 23 years and 16 years of Monday mornings meant that anyone who worked this building with regularity knew Judge Morrow. The way they knew the building itself, as a feature of the environment that had been there before they arrived and would be there after they left. Officer Travis Webb had been assigned to the Morning Post for 6 days. Travis Webb had graduated from the Meridian City Police Academy 4 months earlier. He was 23 years old, had finished in the upper third of his academy class, and had been described in his initial performance assessment as eager and detail-oriented. His training officer had noted that Webb had a tendency to apply rules literally without sufficient contextual judgment and had recommended continued mentorship to develop the discretionary reasoning that field experience typically produced. That recommendation had been made 3 weeks before Webb's posting to the courthouse entrance, which his precinct captain had considered a low-complexity assignment appropriate for a new officer still developing judgment. The laminated sheet was on the post desk when Webb arrived at 6:30. He had read it. He had read the line about judicial credentials granting immediate access. He had also read the line about 8:30 general public access. In the conflict between those two pieces of information, Webb's literal application had produced a resolution that his training officer would later describe, in his internal affairs testimony, as precisely the kind of contextual reasoning failure the recommendation had been designed to prevent. When he saw Judge Morrow approach the entrance at 7:58, he saw a black woman in professional clothes with a travel coffee mug and a leather portfolio. He did not see 23 years of federal service. He did not see the first black woman appointed to her circuit. He did not see the person who had requested the installation of the cameras above his post. He saw a person approaching before 8:30 and applied the rule that governed before 8:30, without applying the exemption that the same rule document specified governed the person standing in front of him. He told her the building opened at 8:30. She showed him her credentials. He told her he needed supervisor verification. She told him about the filing deadline. He told her everyone felt their situation was urgent. She asked him to read the access protocol document he had been given. He told her he had read it and that verification was required. She produced her credentials for the 3rd time. He stepped back to the post position, the position that placed his body between her and the door, and told her to wait in the public waiting area. Judge Morrow looked at him for a moment. She had spent 23 years on the federal bench and had developed, through that experience, an extremely precise understanding of the difference between a person who was being obstinate because of bias and a person who was being obstinate because of inadequate training applied without adequate judgment. She was not certain which one she was looking at. She was certain that the distinction did not change what she needed to do next. She picked up her phone and made the first call. The first call was to the courthouse's chief security officer, David Okafor, whose direct line she had in her contacts because the revised access policy 4 years earlier had made direct communication between federal judges and the security office a documented protocol. Okafor answered on the second ring. She told him her name, her location, and the situation in 4 sentences. He told her he would be at the entrance in 3 minutes. The second call was to her clerk, a second-year law clerk named James who was already in chambers preparing the morning's materials, to inform him that she would be delayed by a security post situation and to ensure the sealed motion was physically accessible for the filing deadline. The third call was to the building's facilities coordinator, not because she needed facilities but because 23 years of federal service had taught her that documentation of an incident began not with the complaint form but with the creation of a time-stamped record of communications that established the sequence of events before anyone had the opportunity to reconstruct it differently. She made all 3 calls in 4 minutes. She did not raise her voice during any of them. She did not move from her position at the entrance. She set her travel coffee mug on the ledge and held her credentials in her left hand and her phone in her right hand and waited with the specific patience of a person who knows exactly what is going to happen next and is giving the process the time it requires to happen. Okafor arrived at the entrance at 8:03. He was 51 years old and had been the courthouse's chief security officer for 9 years. He had worked with Judge Morrow on the revised access policy. He knew her by sight. He knew her by name. He had passed her in the corridor on the way to his office on approximately 400 Monday mornings. He looked at her standing at the entrance with her credentials in her hand. He looked at Officer Webb at the post position. He looked at the entry camera above the door that had been recording since 6 o'clock. He said, "Judge Morrow, I apologize for this. Please come in." He held the door. Judge Morrow picked up her travel coffee mug, walked through the door and said, "Thank you, David. I'll need the entry footage from this morning preserved." "Both cameras." "Already on it," Okafor said. She walked to the elevator. She reached her chambers at 8:06. She met her filing deadline at 8:24. She was in the seminar room at the law school at 9:02. At 8:31, after the building had formally opened and his supervisor had arrived for the 8:15 check-in that had been running 16 minutes late, Officer Travis Webb was called to his supervisor's office and shown a still image from the entry camera above the post position. The image showed a black woman in professional clothes holding federal judicial credentials at arm's length toward the camera while a uniformed officer stood in the door position. His supervisor asked him to explain the image. Webb explained it the same way he had applied the rule, literally, procedurally, without the contextual judgment that the laminated sheet had assumed its reader possessed. His supervisor looked at him for a long time. Then he called Okafor and asked for the full footage. The full footage was 4 minutes and 37 seconds long. It showed Judge Morrow approaching the entrance, displaying her credentials, being told to wait, asking for a supervisor, being told the supervisor was unavailable, producing her credentials a second time, explaining the filing deadline, being told everyone felt their situation was urgent, producing her credentials a third time, watching Webb step into the door position, being directed to the public waiting area, and making 3 phone calls while standing at the entrance of the federal courthouse in which she had worked for 23 years. The footage also showed something that no description of the incident had yet captured. At the 1 minute and 44-second mark, when Judge Morrow produced her credentials for the second time and held them at arm's length for Webb to see, the camera angle captured Webb's eyes moving from the credentials to her travel coffee mug and back to the credentials. The movement took 2 seconds. It was the same 2 seconds that the incident report would later identify as the moment Webb made the decision that supervisor verification was required. A decision that the chief security officer, the precinct captain, the training officer, and the internal affairs investigator would all independently characterize as one that would not have been made if the person holding those credentials had looked different. No one stated that characterization in those exact words in any official document. Every official document produced by the investigation arrived at that characterization through the evidence without requiring the words to be written, because the footage showed the coffee mug, showed the credentials, showed the eyes moving between them, and showed Webb stepping into the door position. And the sequence spoke with a clarity that 23 years of federal judicial experience had taught Judge Morrow to recognize as the kind of evidence that requires no editorial assistance. The internal affairs investigation was initiated the same afternoon. Judge Morrow had filed a formal complaint with the Meridian City Police Department, the federal courthouse's Judicial Oversight Office, and the Department of Justice Civil Rights Division before noon. The complaint was specific, documented, and accompanied by a formal request for preservation of both entry camera recordings. The complaint cited the access protocol document by its revision date, quoted the judicial officer exemption verbatim, noted the 3 times credentials had been displayed, and documented the door position Webb had taken between her and the entrance. The investigation examined Webb's 4-month service record. It examined his training officer's recommendation about contextual reasoning. It examined the 6 days of his courthouse posting and found 2 prior incidents in which his literal application of access rules had required supervisor intervention, both involving individuals who, the footage confirmed, had displayed valid credentials that Webb had not accepted without escalation. The demographic pattern of those 3 incidents was noted in the investigation report without editorial comment, in the specific way that investigation reports note patterns that the evidence establishes without requiring the investigator to characterize them, because characterization is what the disciplinary board is for. Attorney Sandra Hargrove filed the federal civil rights complaint 41 days after the entrance incident. She sought $2.4 million in damages and named Webb personally, the Meridian City Police Department institutionally, and the city for assigning an officer with a documented contextual reasoning deficiency to a post that required contextual reasoning as its primary competency without ensuring the reasoning deficiency had been addressed. The complaint produced a discovery process that examined the courthouse posting assignment decision, the training officer's recommendation, the timeline between the recommendation and the posting, and the 3 incidents that had occurred during Webb's 6-day courthouse assignment. It found that the recommendation had been received, logged, and not acted upon before the posting assignment was made. It found that the 2 prior incidents during the courthouse posting had been reported to Webb's supervisor and had not resulted in any adjustment to the assignment or any additional training provision. It found that the laminated access protocol sheet, which had been drafted in Judge Morrow's chambers, had been distributed to courthouse security with a cover memo that specifically noted the judicial officer exemption as the highest priority protocol on the sheet. The 2 entry camera recordings, preserved at Judge Morrow's request on the morning of the incident, were entered into the discovery record. The 2-second coffee mug sequence at 1 minute 44 appeared in Hargrove's deposition materials 11 times. The city settled for the full $2.4 million 8 months after the complaint was filed. The settlement required mandatory contextual reasoning assessment for all officers before courthouse or federal facility assignments, independent of their general academy performance. It required that training officer recommendations be formally addressed before assignment decisions were made, and that any unaddressed recommendation be documented with a written supervisory rationale. It required the courthouse posting assignment to be classified as a specialized post requiring minimum 6 months of field experience and a specific contextual judgment evaluation. And it required all courthouse entry camera footage to be reviewed weekly by the Chief Security Officer and the Judicial Oversight Office jointly, a protocol that ensured that what happened on that Monday morning could not happen again without being identified within 7 days. Webb was terminated 3 months after the incident, following the Internal Affairs investigation's completion and the disciplinary board's review. His 4-month tenure ended with a termination letter that cited the courthouse incident, the 2 prior escalation incidents during his 6-day posting, and the training officer's unaddressed contextual reasoning recommendation. His certification was not revoked. He had not been on the force long enough to have developed the complaint history that typically preceded revocation, but the termination record and the civil settlement were in the public domain and would be surfaced by any background check conducted by any law enforcement agency considering his application. He was 23 years old at termination. He had been a police officer for 4 months and 6 days. David Okafor revised the courthouse security posting requirements the week after the settlement. The new requirements specified minimum experience thresholds, mandatory contextual reasoning assessments, and a shadowing period for any new officer assigned to the entrance post during which they worked alongside an experienced officer for their first 10 days before assuming the post independently. He described the revision in a memo to his staff as something that should have been in the original posting requirements and that was now there because it wasn't before and that cost something it should not have cost for it to get there. Judge Morrow's sealed motion was filed on time. The proceeding it related to concluded 14 months later with a ruling that was cited in 3 subsequent federal decisions. The constitutional law seminar she taught that Monday morning covered the Fourth Amendment's reasonable suspicion standard, the specific legal framework that governed when an officer's assessment of a situation was sufficient to justify the action the officer took. She taught it the same way she taught it every year, with the same precision and the same expectation that her students would leave the room understanding the difference between a standard that exists in a document and a standard that is applied in a moment when a document is in someone's hand and the judgment required to read it correctly is not. Her travel coffee mug was still in her office. She had not replaced it. The 2 entry cameras above the courthouse door were still there. They had been there since she requested their installation 7 years earlier. They recorded everything that passed through that entrance from 6 o'clock in the morning until the building closed. They recorded it at 30 frames per second in high definition and stored the footage on a secured server for 90 days before archiving. They had been recording for exactly 1 hour and 58 minutes on the morning of October 14th when Judge Constance Morrow walked up to the entrance of the building she had worked in for 23 years and displayed her credentials for the first time. They recorded everything that followed. They always did. The lesson is 4 minutes and 37 seconds long and includes a 2-second sequence at 1 minute and 44. A woman walked to the door of the building she had worked in for 23 years. She displayed her credentials 3 times. She explained a filing deadline. She asked for a supervisor. She was directed to the public waiting area. She made 3 phone calls. She waited 4 minutes and 3 seconds for the chief security officer she had worked with on the access policy that specified she should have been admitted immediately. For months on the force. 6 days at the post. 2 prior incidents. 1 unaddressed training recommendation. 1 laminated sheet with 1 exemption that 1 officer applied one way when the evidence suggests it should have been applied another. $2.4 million. 1 termination. 1 posting requirement overhaul. 1 contextual reasoning assessment that is now mandatory before any officer stands between a federal judge and the building she has worked in for 23 years. It should not require the person who requested the installation of the cameras above the door to invoke those cameras on her own behalf while standing at the door they were installed to protect. It keeps requiring it because the training recommendations keep going unaddressed and the posting assignments keep getting made without the assessments that would make the recommendations relevant, and the laminated sheets keep being distributed to officers who read the rule without reading the exemption until the footage shows what happened when they didn't. If you believe that 23 years and a federal credential should be sufficient to enter the building where those 23 years were spent, share this story with everyone who needs to understand what a 2-second eye movement costs when both entry cameras are recording at 30 frames per second. What specific training requirements should be mandatory before any officer is assigned to a federal facility post? Drop your answer in the comments. And if you believe that $2.4 million is not the ceiling, it is the floor of what it costs when a training recommendation goes unaddressed and a posting gets made and the cameras that the judge installed record the moment her credentials are looked at and set aside in favor of a travel coffee mug. Subscribe. Because we are not finished until the contextual reasoning assessment that should have happened before the posting assignment is the requirement and not the settlement provision.